Very good evening to all of you, and welcome to the launch of the Indian Constitution, A Conversation with Power by Gautam Bhatia. This is a book that examines the Indian Constitution from a new perspective as a document that creates, shapes, channels, and constrains power. To tell you more about the book as well as have a discussion on it, we have a 4-member panel here who will provide different perspectives on the book and its topic. I'll just briefly introduce all of them. So, Shadan Farasat is the Additional Advocate General for the State of Punjab and a Senior Advocate at the Supreme Court. Seema Chishti is a journalist and author and editor at The Wire. Sasikanth Senthil is a Member of Parliament representing the Tiruvallur constituency. He is a former officer of the Indian Administrative Services. And of course, we have Gautam Bhatia, our author, who is a practicing lawyer and legal scholar. He's the author of several books, including The Transformative Constitution and Unsealed Covers, both published by HarperCollins. So before the discussion begins, we'll have a quick launch for the book. So I request all the panelists to please hold up the book for the photo op.
Congratulations, Gautam.
Save some paper with no writing. Yeah, actually. Good thought.
All right, so now we'll begin the panel discussion. It will start with Gautam telling us a little bit about the book, about its themes, followed by Shadan Farasat, then Ms. Seema Chishti, and finally Sasikanth Senthil. It will conclude with remarks by Gautam again, and then we'll open the floor for questions. So let's start, please.
Yeah. Thanks so much for the introduction. Thank you to everyone for coming, and of course, thank you to my co-panelists for being here, reading the book. For Seema, it's the second time struggling through my books to come on a panel. Third time. Okay, sorry. That's yeah. Okay. Yeah. Thank you so much. I'll just very briefly outline the book's themes and hand over. So this book is the result of perhaps 4 or 5 years of work that involved both practice primarily in the Supreme Court and then reflecting back upon that practice. And through many of the cases that I discuss in the book, it struck me that the way we often discuss the Constitution, there are things missing from that discussion. So we often focus a lot upon fundamental rights, Part 3, what the courts are doing, how effective they are in protecting those rights. And sometimes we talk about other parts of the Constitution, the federal scheme, separation of powers, but always in an isolated way, as if there are different parts of the Constitution that are discussed on their own terms. And my experience in engaging with practice was that these themes are often linked, and often one case presents more than one part or one theme of the Constitution that is closely bound. So Granville Austin, in that iconic book about the Constitution, calls it the seamless web. So I did think that was accurate. The web was accurate. Seamless, I don't know. But the web bit did seem accurate with many different strands. And the connecting theme through that for me was power. So the Constitution is a power map. It sets out a terrain or a map of the way that public power is created, channeled, distributed, and constrained. And in all these cases, the Constitution became a terrain for contestation between different visions of power. So on the one hand, there seemed to be a vision that was decentralized, distributed, more equitable, perhaps more democratic. And on the other hand, there was a vision of power that was more centralized, more concentrated, more flowing to the central executive, essentially. And so experiencing that and reflecting back upon that, I began to read or reread the constitutional canon, keeping this vision in mind. And that brought me to the conclusion that yes, the Constitution is a terrain of contestation between these different visions of power. But there are two things. One is that both in the Constitution's text and its design, and the way it was very intentionally and consciously drafted by the framers, and in the way that over the last 75 years, the court has interpreted these provisions, there has been what I call a centralizing drift, which is to say that both in the design of the text and in the interpretation, there has been an incremental and gradual but very tangible shift towards centralizing power over the years. This shift has not been uniform. There have been moments where it goes the other way. And it's not inevitable in the sense that interpretation is always open-ended. So constitutional texts are open-ended and you can have counter readings. But broadly, that is what has happened. And that in turn leads me to a couple of conclusions. So one is that often when we talk about the Constitution, we talk about it in a certain kind of reverence, a certain kind of awe. We attribute a certain kind of wisdom to the framers, and then we tend to contrast the Constitution's quality with often bad judgments, which we think are bad judgments, and we draw this distinction between the courts misreading the Constitution and the Constitution itself being a document that is, in a certain sense, ideal. So one thing I do is I question that reflexive assumption that we have, and I argue that, in fact, many of the seeds of the problems that we think we face today are not just with judgments that interpret the Constitution in a certain way, but are attributable to the design and the structure of the Constitution. There were reasons for that, but also it seems to me that the framers were influenced by their immediate context. And so many of the provisions in the Constitution are a result of that immediate context. And they weren't thinking so much about how this would look like perhaps 75 years in the future. So that's one thing. And the second thing is, of course, that, like I said, that isn't inevitable. So interpreting the Constitution is always a matter of choice. And so in each chapter of this book, where I examine one particular axis of power, I argue that at various points in history, the courts and the Supreme Court primarily have been faced with that choice. How do you interpret the Constitution's power map? One path takes you down the path of centralization and one path takes you down the other direction. And more often than not, the courts have made an active choice to go down the centralizing path, which again explains to a certain extent what the situation is today. So that, in a sense, is the argument of the book. And in the end, I say that one thing we need to understand is that these axes are all linked. So federalism, rights, asymmetric federalism, pluralism, diversity, these are not separate, these are all linked. So, for example, often protecting the federal scheme will mean protecting rights as well, and the other way around. So centralization will mean your rights also suffer. So we need to look at the Constitution again as a web with strands of power, and ask ourselves what we think that web should look like, and how we should get there. So I will stop with that and hand over to the panelists.
Yeah, thank you, Gautam. Thanks for having me on the panel. I really enjoyed reading the book. Parts of it, I'll admit, I speed read it. But I think broadly, I will firstly recommend this for any serious constitutional scholar or person who's interested, especially constitutional law students. When I studied constitutional law, it was taught case law by case law, and you really don't know what the dynamics of what you are fighting for. And really, this book tells you what you are fighting for. It's about power and powerlessness and how that is embedded in the Constitution in terms of how you address that issue of why somebody is given a power, how is that power restrained, and when does that, who polices that power in the Constitution. So it's really about what is at stake in the Constitution is what this book is about. I would really recommend it to especially law students, because you really understand why you are studying constitutional law in the first place. It's not an abstract question of just studying some case law, which is the way I remember my law school years of having studied constitutional law. Now, I also really congratulate Gautam for having written this book so beautifully. It actually uses 2019 to 2024 a bunch of case laws, a lot of which I have also been part of, Gautam has also been part of in terms of either arguing those matters, and then putting it in the macro setup of what the Constitution was meant for. And it connects both the macro and the micro beautifully. So I think it really does that job in terms of using those 5 years, but to explicate a larger issue. And his fundamental thesis, if I've understood correctly in the book, is this: that really speaking, it's not about the people who administer the constitution or work the constitution, namely the courts or the administrators or the governors or whoever, there is something fundamentally questionable about our constitution itself which we don't talk about, and that's what he was alluding to, which is that at the point of framing, the constitution in effect, for a whole host of reasons, two of which I just want to highlight, and I do agree with Gautam on that, is one was that Dr. Ambedkar's own sense of the fact that the local was prejudiced, that is, his experience of the village was effectively as a Dalit, as somebody, local was something which was problematic. Central was something which was liberating. It was cosmopolitan. The city was cosmopolitan. He had studied a lot abroad, etc. So that was cosmopolitan. Therefore, he, for his own reasons, seemed to have a centralizing drift. And anybody who's seen the Constitutional Assembly debates will notice that members of the Constitutional Assembly raise a question, and in the end, Dr. Ambedkar comes and sort of validates the centralizing line of that particular provision. And I think that instinct was played along with the instinct of the Indian National Congress and Prime Minister Nehru at the time, which was that we are a fresh country, we are not sure about our unity, we have to go together, we have to really lead the people, as it were, not just follow them, and therefore we need a centralizing force. So I think both those things got wedded at the time of inception of our constitution, and therefore the constitution, as what Gautam calls it, has a centralizing drift in it. And I think we need to sort of recognize that to begin with. And then he discusses along different axes, in state versus union disputes, in fundamental rights versus government dispute, in parliamentarian. I mean, he discusses something which I don't think has been discussed in constitutional law books, like the right to opposition, in terms of what rights do opposition members have. We have seen 130 members of the opposition just rolled out and suspended in last year. So in terms of all of those things, he discusses power and powerlessness and where, what does the constitution say? And his thesis really is that we have to not just address the people who sort of, ban this constitution, but also really understand if there's a fundamental bias to begin with. Although I think he rightly recognizes at the same time that it doesn't matter, you still can work the constitution in a more democratic way despite that bias, right? I'll just give two examples. I don't think it's there in the book, but when I was reading it, it occurred to me. So there's a very beautiful chapter on federal disputes, and he's discussed the Delhi matter, but I won't discuss that. That anyways, two constitution benches, and the third one, I don't think we'll see the third one anymore. But there are two other decisions which have come out. One was on a 9-judge bench on mineral rights last year, and the state's ability to, the state versus the center's ability to sort of, so the Supreme Court overturned its earlier judgment which had a centralizing drift and made it a federating one. And second was a matter in which I had the opportunity to appear, and that was on, again, power to impose fee on liquor per se, industrial alcohol as they call it. And there again, they overruled the earlier judgment, and the 9-judge said, so when you want to do it, you can do it. Despite the centralizing force, you can do it. So I think I agree with you that there is a strong drift, but I think there's a part disagreement, if I can say, on the point that despite that, there are ways and means of actually making the constitution much more democratic if you want to do it, if you're in a position to do it. So I'll just stop with that opening remark.
Thanks, Shadan. So as Gautam said, I'm like a senior on this panel. This is my third panel. But I'm going to start by embarrassing Gautam. So Gautam completely, his kind of just universe with speculative fiction, with law is truly commendable, because I think the depth and passion, both things that he brings to them, makes it a treat to just follow his timeline. And there's so much of learning from there. And I say that not because he's sitting here. That's like brilliant. And often we think of what live law and bar and bench have done to Indian reporting or understanding of courts. Earlier it was only scenes in Damini or Hindi cinema or Tamil cinema that show you the courts, which were the popular imagination. They brought the courtroom out, reported on it. And I think Gautam and this cohort of people around him as well, I mean, others like him, have lifted that to a completely different level. Their analysis at a time when newspaper op-eds are essentially dead, but you have this living kind of serious commentary, like people are worried about, they get either enraged, they take a sledgehammer to a court order, or they just retreat. He takes a scalpel and he teases out the arguments and makes it effective, makes you understand that. So I think that's like, he's really doing yeoman service to the whole thing. He does that brilliantly, and both his books have kind of done that. This book also is excellent, as my co-panelist Shadan said, that in terms of the entire understanding of all central arguments that have been there, whether it's Kashmir, whether it is Maharashtra, where he talks about different kind of institutions and how they interact and make the constitution come alive, or make democracy work more beyond the constitution work. But I come to what is my fundamental disagreement with the central drift, the centralizing central drift of Gautam's book about that. So in my palimpsestian kind of view, I don't think it's kind of only emotional to defend this book, to defend the Constitution, I mean, because I want to introduce, there are courts here, there is parliament here and all, I want to introduce context to it. As we stand in 2025, I think a document which has been amended 106 times in 75 years speaks about its tenacity and its ability to survive it. I mean, you repair, you refit, you restructure, and it's still standing there. And holding this diverse, plural country together speaks to me of its innate strength and flexibility. There are silences in the Constitution which to me are reflective. I have a very palimpsestian kind of view of the world and of India, but it kind of tells me about how they probably imagined it would be, and therefore they did not impose a very strict thing on, say, socioeconomic principles, because they thought maybe that's to be left to Parliament, to the opposition, So I think they left a lot to reason, and it's important to look at their context too. You have 555 princely states. We're sitting here, we have the luxury of sitting here 75 years on with no Maharajas kind of winning elections only because they're Maharajas, and we take that for granted. India was a very different place when this constitution came into being, and we cannot forget that. So for me, that's not a limitation of it. They're guarding us against what was an impulse of where India would have gone had that drift been allowed to take place. So I think the constitution is a hugely capacious, brilliant, wide document which has made India kind of possible. I had sort of beef to pick with Gautam on also the phrase of, you've been a little harsh on the preamble, you call it preambilic fiction.
Just on We the People, just those lines.
Yeah, but for me, the preamble has been written for that reason. It's like you have in the Olympics, you have Altius, Citius, Fortius. You always strive for higher, stronger, faster. That's the job of the preamble, to set it up. So I don't think that's not a good critique. The preamble is what is to serve us to be what, it's not about that we're the most just place, economically equal, etc. No, hold on. That's the aspiration. So maybe even 200 years on, you're jumping that much higher because I have to reach that much on the pole jump. So I think that's important. And at a time when the Constitution is being challenged desperately, for me, the Constitution wins everything for the one thing it gave India, which was the right to equality. The right to equality in a deeply unequal society with brilliantly practiced graded inequality across regions, religions, and places. For a document to be able to do that, for me, it always stands a test of time. And now we have a regime which clearly says it does not believe in the right to equality in the way it kind of functions. It has its idea of graded citizens. That a whole lot of conditions apply. There's an asterisk put on, like Article 19 and, of course, Article 14 as well. I think in a time like that, when you have the Constitution, which appears on stone tablets in Patalgadi, which is waved up as a poster and as a meme on the CAA, at a time when basics are at stake, for me, I would pick what's like really cool about the Constitution and do it. So I'm not taking away the right of people, and they should do that. And I think I just love the end when he talks about it, that he has started the kind of debate on 75 years on after the Constitution. There should be a debate, and he's put it out. I don't see, this government went kind of apoplectic with 75 years of Azadi. I don't see that happening in the Constitution. They don't want to particularly discuss it. So I would be very careful looking at context 2, which is now, and at context 1 when the Constitution was built. And so for me, that's my beef with the centralizing theme. But I think just in terms of telling me over the past 5 or 6 years, detailing the law and making me fully understand how the various players that constitute democracy are stepping out and building this cobweb, if you like, or this pattern or this puzzle or whatever you may want to call it, is okay. I get a little worried about calling it a cobweb because then you want to sweep it away. And there are so many PhD students are being urged to write about how the Constitution is kind of ho gaya uska ab. Let's kind of come up with something better, new. This Constitution is colonial. We had a book kind of championing that. So I would be very wary about not reading the Constitution fully conscious of not just the politics, the executive, parliament and courts and how they interpret it, but the fundamental context, and recognize how important the time India is standing at as far as its democracy and its big journey as even a modern Indian republic goes. And so for me, I'd embrace the Constitution very close to my heart. Thank you, Gautam, for writing the book.
Thank you, Seema, and thank you, Shadat. And first of all, congrats, Gautam. So, like Seema, my view on the book also was mixed feelings. but it gave me a different perspective of how things are. Like, in the sense, we are generally used to reading what the constitution was, how it came into being and stuff. But what is happening with the constitution and what is happening to the society in large is also a prism to look at. So when Gautam talks about the centralizing drift, I often compare it with what Dr. Ambedkar said at that time. The idea of democracy from a political perspective is what we had achieved. The society is still moving towards centralizing patterns. So for me, coming from a background that I come from, this has been the only protecting shield that we had, and without this shield, I don't think that equality would have happened in this country. So considering all that, and also aware of the fact that time and again courts, the way they have interpreted the constitution and how they have enabled this centralizing drift in many ways, is also a prism to see how the constitution is moving towards. But apart from everything, one cannot deny the role that the constitution has played in kind of so Gautam talks about contestation of federalism and centralization. There is always from a societal perspective, if you see, I see our entire country has been in a contestation for a long time. Hierarchy and equity has always been in a contestation. Religions have come out of that, from Gautam Buddha to what we are fighting for today, is always this fight between people who want to move towards hierarchy and people who want to establish an equitable society. So that's reflective in our society in many levels. Of course, whenever there's a victory towards the equity side, the other part starts hitting in multiple levels. So I think that's the trend which is also being noticed, what is happening with the constitution. But it is still the shield, it is still the wall, it is still that fort which is protecting a lot inside. Yes, it is taking a lot of hit. So I see it from that perspective, and I'm very enamored with the fact that it is still standing on its basics, right? So also acknowledging the fact damages are also happening. So by having an acknowledgement towards that, I think we will be able to pretty well to get to see how we are progressing and what is happening. I like the way he brings in a lot of codes and a lot of cases to explain his case. All that is very very nice and gives a very different prism to see the constitution, rather than reading the constitution in terms of what it offers and other things, how it's actively protecting and how it's taking the damage and what is happening to it from a very organic perspective is what I could see and sense from the book. I also in fact I also had quoted that he's said that very sarcastically, like the people, the word people, only in the preamble, after the preamble it has vanished inside the constitution. So there are many wonderful things to read in this book. I think everybody will have an opinion about what he has said, because he said it very clearly and very precisely. So in that way it's a very nice read. I couldn't stop reading it, because what he was arguing questioned my own understanding and feelings about the constitution has got touched very strongly with this. But then I could also see what's happening and also now start appreciating the constitution from a different perspective. Thank you, Gautam, for that.
Yeah, thank you. I think that maybe I'll put a bit of context as well to I think what initially prompted this writing of this book, and that might address I think some of the questions that Seema and Sasikanth both raised. And this is actually in the immediate aftermath of August 5th, 2019, which was of course the abrogation of Article 370. And this is a case that Shadan and I both worked on. So a couple of days after that happened, I was approached, I was engaged to draft one of the challenges to two presidential orders that did that. And when I examined those presidential orders the first time, and read them in some detail, it seemed to me that from the perspective of constitutional law, this was as open and shut a case of constitutional illegality as there could be. Did that mean I thought we would win the case? No, that did not mean that, because all of us who have been in court, are aware that there is often a gap between, constitutional illegality as we see it and as the way the court sees it. So I didn't think that. Right? I did think that, that this was, if anything was unconstitutional, this was it. And then we were given only 48 hours to draft the challenge, because that's what happens in practice. And in the course of those 48 hours, reading non-stop, basically, gradually that conviction began to waver quite a bit, because what I saw was that when I read Article 370 and I brought to that reading certain beliefs about what it meant and stood for, it was not just the presidential orders of 2019 that seemed to take the opposite view, but there was this consistent line of precedent from the Supreme Court starting from the 1950s, which seemed to be reading this article in a very strange way, in a way that made no sense to me. And the more I read over the months following the petition, it became clear that the court was bringing to this article a certain ideology of the way they thought, what they thought it was meant to be doing. And what they thought it was meant to be doing was basically, again, in the words of Nehru, serving as this tunnel that would then, through that tunnel, you bring in the rest of the Indian constitution as into Jammu and Kashmir. So when I saw Article 370, it seemed to me to be a classic case of what in constitutional theory we call asymmetric federalism, which is that different, based on history, language, ethnicity, and so on, any diverse country should have differing constitutional arrangements for different parts of the country. And that's something that is good thing in itself and should be protected and defended. So that I read the article 370 from that perspective, that there is a principle here at work, a principle that India's diversity should be reflected in the constitutional arrangements, and that is how we should read what's happening here. Whereas the way the court had been almost consistently reading it for the last 70 years was that this was extracted from the Constituent Assembly purely by way of geopolitical, almost like blackmail. It had to be given because, that was the price of having the nation state come into being as it was. But the ultimate goal is to ensure that at some point we will have a uniform constitutional arrangement, and there'll be no asymmetry and no pluralism in the way that different states have powers and status, right? So this idea that a state could have its own state constitution or flag, which is actually very, very mainstream in global federalism, the US, all these countries. There's nothing wrong with the state constitution or the state flag, but that was something that was just never, on the table. And the thing is, once you see the ideology at work, you can't unsee it after that. And it began to appear in all cases then when I read. So whenever I had a case, I used to think to myself, did what I read in the Kashmir precedent, am I seeing a replication of that in this other case involving, say, West Bengal arguing that the center should not acquire coal mines, in the state because that's state property. And again, it was coming up there. And then, I went back to the framing debates, and I could see that whereas those judgments, I didn't agree with them, but there was some warrant for what they were doing in the assembly debates, because the framers were actually intending to craft a constitution of that kind. I'll give you one very interesting example, which, and it just again shows you how just one word can change, everything. So list 1 of Schedule 7, which is the competence of the Union to make laws, has an entry called Central Bureau of Intelligence and Investigation. And so what happened in the assembly was that many times they would quietly add like one word here or there, behind everyone's backs, and then present the draft to the assembly as a fait accompli, basically, like, look, now vote on it. And then, of course, there would be protests, like, where did this word come from? And one of those words was investigation in entry 8, because the argument made by assembly members was that policing is a state subject, and the moment you put in the word investigation into this entry, you will effectively authorize the union to create its own police force, which will then effectively render the state, subservient, because it will take over investigations at will. in all these states. And Ambedkar very blithely says, don't worry, obviously it's so clear that investigation must be read in light of intelligence, and so therefore it just means the same thing basically. So don't worry, nothing will happen. Of course, that's not the way it panned out. The word investigation there is then what authorized something like the CBI to come into being and to then get this expansive jurisdiction over the years. And in fact, in 2012 or 13, the Bombay High Court picks upon this history and says, look, there's a reason why they had the word investigation, and that reason is, this was the case about the NIA's jurisdiction. And therefore, clearly, this idea of a central police force that could intervene into the states is clearly constitutionally sanctioned. So I talk about this example because I think it really shows you the links between the way the constitution was designed and drafted, the intentions behind that, it wasn't accidental, the way that then it's interpreted by the courts, which then links up to many of the issues that are present today, right? So today, of course, there's a lot of issues regarding, again, the way that central investigative agencies, effectively have taken over, a large swathe of what would be state functions. And when we talk about that, we often talk about it as an abuse of power, right? We talk about it as, look, the center is abusing its power. This is clearly an overreach. And this is not sanctioned by our existing, federal structure. There's something, it goes beyond that. And I think what at least struck me when doing the research for this book was that to an extent, yes, it is an abuse of power, but also it is something that's not entirely alien to what the Constitution intended. Because, again, as Shadan said, there were reasons for that. There were reasons at that time why they may have thought this was a good thing. But ultimately, you can't wish away the fact that there is a root of this in the Constitution. Now, what that means, going forward, that's an open question. But I think that just talking about abuse of power without talking about the way the constitutional design is in a way on all fours with that abuse would be to have an incomplete discussion, because then we are losing out on a very important bit. Finally, just one last thing. And I think one thing is that this is never permanent, right? So in one example I give, so in the penultimate chapter, I talk about these moments in history where there could have been alternative visions of power that flickered for a while and then were extinguished. And one of them was the emergency and post-emergency, where in the 44th Amendment, they attempted to undo many of the centralizing features of the 42nd Amendment, which Indira Gandhi rammed during the emergency. And again, the striking thing is how incomplete that attempt was. So, for example, education was moved to the concurrent list from the state list. It wasn't moved back. And so there were many examples where I think there was a chance to perhaps rethink the power map of the Constitution now that in 1977, 78, we were independent for 30 years. Were those founding assumptions still entirely valid? There was a chance to rethink a bit of that. And I think that chance will come again at some point, where, in history there are always cycles. So we will be able to rethink again if there are alternative, more egalitarian ways of imagining the Constitution or parts of it. And I think the purpose of the book is to perhaps try and initiate that conversation, and should we think about ways in which we could make the Constitution more equal and think about some of the issues and how we could solve them in terms of design and not just abuse of power. So I think that's the basic goal, to start that conversation. And I completely take the point, of course, that is not to in any way diminish the importance of the Constitution as a shield. And its very important leap, both in terms of equality and universal suffrage, which at one stroke transformed India from subjecthood to citizenship. That's again very important. So keeping those core elements of it in our mind, and also then asking what other parts of it we could think of moving towards a more equal direction. So I think that's the goal of this book. I'll also stop at that point, and I guess we could open it up for any questions or comments or thoughts from the audience. Yeah, go ahead. I think the mic is coming from somewhere.
Hi, I'm Abhineet. I'm a fifth year law student at National Law University, Delhi. I had two questions. First, related to the constitutional common sense that you talk about while you're talking about the centralizing drift. What I wanted to ask is, in the way that you sort of theorize this idea, do you think it to be like a sort of artifact that is very much intrinsically connected to the idea of the centralizing drift, or do you look at it as a general feature of constitutional regimes, in the sense that every regime sort of develops its own constitutional common sense which sort of operates in different ways? And if yes, I want to ask, like, what do you think are like sort of other constitutional common sense that are like sort of polity has, which may or may not be related directly to this centralizing drift? I mean, I'm coming both to you both as you are a practitioner as well as a scholar. So from those different perspectives, where do you see this playing out more broadly? Second question is more speculative in nature, because it's more a legal philosophical question rather than a legal historical question, which is sort of how I see this text. It is that you obviously point out that there are alternative ways in which we can sort of look at Indian constitutional history, but what is the normative reason why we should take that alternative path instead of sticking to this path that we are taking? Because there is obviously tendency within legal philosophy to say that what the dominant history of a legal tradition is something that needs to be given its due deference, right? I mean, you think of the Dworkinian chain novel idea. So what is the reason to read this novel differently? Why should we go ahead and look at the constitution differently? What do you think is the reason for that?
Yeah, so on common sense, and I'd like to bring in Shadan also into this, because obviously, it's something he's experienced as well. So I'll give you the example that I had in mind when I thought of constitutional common sense. So in the book, in the opening chapter, I speak of constitutional common sense as basically a set of assumptions, often unspoken and unarticulated, about the way the Constitution should be understood. These are not things you will see written in books or in papers, but it's just the way that people internal to the practice behave. This could be judges, lawyers, and beyond that, academics and citizens as well. So again, Article 370 again is the case I always think of. So there was this debate about the status of the Constitution of Jammu and Kashmir. And this was one of the big issues in the case. And like I said in my opening remarks, the idea that a state, a federal unit, could have its own constitution is very mainstream federalism across the world, not just US, but multiple countries. And it's not in any way antithetical to federalism. It doesn't mean that state is in some way seceding or is independent in its own way. It's not at all. It just means that to govern itself, it has a constitution, right? And so in this case, without going into specifics, there was one big issue about the relationship between the state constitution and the Indian the federal constitution, right? And it was basically impossible to make the argument, to make any argument other than the fact that the Indian constitution occupies a hierarchically superior position to the Jammu and Kashmir constitution. It basically was not possible, and in theory it shouldn't be impossible, right? Like I said, you should be able to make the case that these are two constitutions that occupy a complementary position and read them harmoniously or whatever. There are multiple positions you can take. But as lawyers, who were in the case, who were making the case, it was very clear that it was an argument that you couldn't make. It was not possible. It wouldn't be taken seriously, right? And so ultimately, you don't make it. And that in every case which you do, both constitutional and non-constitutional, there are arguments that if you ask somebody who is not internal to the enterprise of legal interpretation or legal practice or even legal scholarship, they would think, yeah, it makes sense. Why can't you make the argument? But there are things that are deemed to be off limits, in any constitutional culture, and that is only something you imbibe as you're socialized into it. Are there other examples of that? Yeah, I mean, it's not just in the federal context, but again, for example, just something that just before this panel began, my friend Abhinav, who's somewhere over there, sent me a blog post with regard to the reverse onus clause, right, in criminal law. Now, it should be, in theory, possible to argue that there is this fundamental principle of innocent till proven guilty, and a reverse onus clause in terms of this burden, a presumption of innocence, is therefore very clearly unconstitutional. That's an argument that you can't make in an Indian court, right? Like it's not possible. Now, why? It's because there are certain assumptions about the way the criminal justice system is meant to work in India, and a certain idea of the role of investigation in terms of privileging the finding of truth over preserving the right, which is all unspoken, but it's there, right? And that determines what you can say and what you can't say in court. So I think, it's across the board, but maybe you have something.
No, so I'll just, on the constitutional common sense, so those who've not yet read Gautam's book, the point he's making is that if something is really open to interpretation, then on that question, normally the court has broadly swayed in a certain direction. And that direction, for instance, in a federal dispute is in the context of the center. Like he said, if that is an open question or an undecided question by the text, then that direction is broadly in favor, not of necessarily of the accused, but finding the truth, as it were. So that's broadly, and that's quite problematic by itself. I think that's true, although with exceptions, as you yourself note in the book, so there are enough exceptions to that. But I think now is a time also, I just want to make 2 points. One, that on Kashmir, I find our Supreme Court, even within that constitutional common sense, treating it quite differently throughout. I think there has been a differential treatment in terms of jurisprudentially and otherwise. So, and that is quite evident in the 370 matter, that the fact that you couldn't argue that really speaking there were two constitutions which were equals, but there was an instinct, really that Indian constitution was clearly superior, whether text supported that or not. So I think on Kashmir, the Indian Supreme Court throughout, Damnu, etc., all the other judgments, you sort of look at it, you see a treatment and more of a concern on the federal question. But generally speaking, I think now the time has come that at the time of our inception, there could have been insecurities in terms of our territorial integrity, right? I can, as a 10-year-old, I can even imagine in early 90s when Kartar Singh was passed, that Punjab, it felt like, as a 10-year-old, I think, it almost, if you watch the media, will feel like, Punjab is going to be now out of the country. So I could even understand, although I know you're critiquing that, but even then one could understand. But today, is there a question on India's territorial integrity? I mean, do any of us have it? The answer is no, right? So the fact that there is territorial integrity is not a question mark really, is something that common sense should change now. That you have, for whatever your original objectives, you have territory. In fact, even Kashmir was not a territorial integrity question. That's the way we framed it to the court. It was a question of how you administer assuming territorial integrity of Kashmir, correct? But, and the form of governance was the question in 370, that you have given more autonomy. The question of territorial integrity of Kashmir was never up in question before the Supreme Court. But today, given 75 years on, where at least to my mind, it doesn't seem like that's a question, the common sense should be in fact the reverse. So if there is a constitutional common sense which is used to interpret these things, that should change with the passage of time depending on what stage where you are as a country. And a lot of those questions, I think, even on criminal matters, the fact that this obsession with finding the truth has led to so much mistrial as experience, the fact that you have now experienced it over so many years, should again lead you to think that constitutional common sense as a means of interpretation should change. So I think that's a very important point you make. But there is also an argument to be made that at the same time, it's time we rethink some of those given our experience over the last many years.
I don't know if you'd like to comment on that as well?
No, just a second question is an interesting one, that why should we question this at all?
Yeah,
My answer would be to kind of take it forward, to take it further down the road of not like, this is terrible, so let's just have a Hindu Rashtra, or let's have a Islamic Rashtra or Christian Rashtra, but take it even more further to achieve the kind of high ideals which the preamble lays out and our fundamental rights. So yeah, for me, if there is any bid to go further into this question, would be to make it more equal, more just, more valuable, every life, every Indian's life.
Yeah, I think the alternatives that I sort of illustrate in the penultimate chapter, I think it's more just to illustrate that there were other kinds of constitutional imaginaries at work, and then let the reader extrapolate for themselves that do they find these attractive, do they find these interesting, do they think, for example, that M.N. Roy's constitution, which envisioned, say, a right to recall of legislators, would that perhaps be something that would have been interesting? Would it have reduced the distance between the legislator and the individual? So it's more to just illustrate that that the constitution or this version or this understanding of constitutionalism is not the only possible understanding in every respect. There could be different parts of it that people have rethought over the years, and that's, I think, a constitutional tradition is alive if we are always doing that task of rethinking and discussion. So to give illustrations of that kind of rethinking that has taken place in India over the decades, and then the reader decides what they think about those experiments, let's say, in alternative constitutionalism at multiple points in our history. And I actually think that even the 44th Amendment was a partial experiment, right, in trying to decentralize the constitutional structure. Yeah, it was a partial one, and that's why it left many pathologies still unaddressed. But it was, you could see what they were trying to do, and then, that's sort of the goal over there. Many questions.
You can take two at a time.
Maybe we start on that side. So one and then two and then
Hi, my name is Ryan. So, Gautam, thank you so much. I've been a long time follower of the blog and your past books. And so one thing I'm curious about, as a reader of the blog especially, and even unsealed covers, when you report on a case, there's often this feeling of, you lay out an argument of, here's how one could logically think about the facts of this case or the constitution or something. And then you report what the court does, and there's some sort of arbitrary, it's not really clear if there's any logic behind what the court has done. And so that's on one end. And then on the other end, you're sort of outlining a much more cogent ideology that, if the court or the parliament or anyone wanted to read the constitution in this centralizing way, they could do it, and that would also justify many of the decisions that we might disagree with that the court has taken over the past 5-10 years. I'm curious if you think these two interact, or maybe that this, foundational centralizing force in the constitution enables that form of arbitrariness, or if it's also just the fact that this is our political moment and the court sometimes has, exogenous pressures to behave arbitrarily and perhaps illogically. Yeah, thank you.
Thank you. Congratulations to Gautam for writing this interesting book. So actually in 1976, 42nd amendment to the constitution was made, wherein the words socialist, secular and integrity were added to the preamble of the constitution. So I have two sub-questions related to it. What were the motivations for doing it? And secondly, 49 years down the line, has it proved to be, correct, or, what are your reflections on it? Thank you.
Can I also add a question? So we will take a couple, and then, because otherwise it'll be, so we'll just go via from that point to this point of the room. So I can just take we can take three, and then we can go here center and then to right.
Hi Gautam. My question is basis a parallel that you draw in the book. You use a very interesting phrase. You say you use something like a constitutional bodyline bowling to probably mean an executive having, say, a majority in the parliament and pushing through the limits of the constitution to mean what is constitutional, to push the limits of constitutionalism, that is. So what you do is, in footnote number 5, if I'm not wrong, you say that this is not something new. What has happened between 19 to 24 is not something new. This is something that even, say, somebody like Nehru has done in the first 15 years or so. So if I have certain reservations regarding that particular example, because if I were to see the first, say, 15, 16 amendments that were passed during Nehru's time, the two major themes which emerge are regarding, say, amendments regarding reservation and, say, land reforms. And like Seema also mentioned, perhaps the most, say, rudimentary vision of the constitution is equality of all kinds, say, social equality, political equality, and economic equality. So most of Nehru's changes, which I see in the first few amendments, are towards achieving social equality and economic equality. Even if I were to keep the question of freedom of speech apart for a while, when you compare that or draw a parallel of the present times with Nehru's changes, what I can think of is probably Ambedkar's statement, where he says that any constitution is as good as the hands in which it falls. So Nehru's changes, while Nehru's changes were gearing towards achieving the original intention of the constitution, what we are seeing now is probably moving away from the original intention. So how justified is that comparison? Not just, say, in your opinion, but also the panel, because the changes that we saw during Nehru's time, the changes that Nehru pushed through, can they actually be equated with the changes that are now being pushed through? That's my question.
So anyone should okay, so I'll address them first, and then also if anybody else has comment on that. Yeah, so I just rechecked because I don't think I wrote that, I made a Nehru comparison, because what Nehru did was he amended the constitution. So that is not constitutional borderline bowling So first of all, the genesis of the phrase is constitutional hardball. It's an American phrase which Mark Tushnet invented. And of course, hardball is baseball, and I thought, we're India, so, borderline bowling is a more, a homegrown indigenous expression. But no, so Nehru amended the constitution. It was very clear what he was doing. I think, of course, there's a debate to be had about the nature of those amendments. And in fact, I think actually the story is a little more complex in terms of, so I actually think that those amendments were quite ambiguous, and deliberately so, in terms of land reform. But that's a different issue. I think that borderline bowling of this kind begins with Indira Gandhi, right? So there is like various things that happen during that tenure, which expand executive power in certain ways. Now, I think the thing about borderline bowling is that it's not technically unconstitutional, right? So it's basically the executive testing the limits of how far it can go. And I think this is actually something that is not unique to any prime minister, like in Indian history, or any executive anywhere in the world. Because I think one thing we often miss is that we think the courts are the only organs that are interpreting the constitution. Actually, all the organs of state are interpreting the constitution. In fact, they are constantly doing that. And we often miss out on how parliament interprets the constitution, its own role, how the executive does that. And every person occupying that, or every institution, will want to expand its power at the cost of other bodies, and that is when it becomes the task of the other bodies to check that tendency. Now, in the Indian context, unfortunately, and I discussed this, because of design features, the ability of Parliament to check the executive is somewhat limited, except in a coalition government situation, because the Constitution actually disempowers Parliament in certain fundamental ways, such as no opposition rights, no opposition days, things like that, and I've discussed that. And therefore, you look to the courts then as the other power holders to do that. So I think, to answer the question, I don't think Nehru was involved in borderline bowling. He was involved in amending the constitution. That's a different debate. But after him, I think regularly, and this is not common to one regime, there have been instances of just executives testing, can I go this far, can I go this further, will I be stopped, will the court stop me, will I lose the next election if I do this? And that's the push and pull that's part of anything. Every country, every executive, it's not unique to India, and it's maybe not even necessarily a bad thing, right? The push and pull is actually through that push and pull you get, you have checks. The problem is when other bodies stop checking, the executive. So that's when you have, I think, issues arising, and which is, I think, one thing that's happening now. But I don't know, other comments on that?
You're very right. In fact, this is a very complex adaptive system. This is not just the constitution, not just the judiciary, parliament. We have the society, we have us, political parties. So many things are in complete, mix and match. I like this metaphor of the constitution kind of being a blueprint. At the end of the day, the nation has to be built on the blueprint. And while you build the nation, there are different forces. And that's why I keep insisting on what our society is. It's fundamentally centralizing. It's fundamentally not equal. It's fundamentally hierarchical. And that's why I'm completely relying on the constitution for my survival. A lot of states, they say that we want separate statehood, nationhood and all. I am not ready to go there. There's no constitution there. Sorry, I come from a state where that is propagated, but I don't want that place. Because this is the shield which is protecting me. And so you're very right. Everything depends on how it's being handled. And we can see why it is being handled the way it is handled. And that is the part that I think we have to understand as we progress, why these forces, why these absurdities are happening, and why it didn't happen then. So it's very clear for everybody to see.
Yeah, so on the first question, I think, which was a really, really interesting question, and I think that gets to the heart of, I think, what part of what I'm trying to do in this book is I think you're completely right in that many of the judgments that we see today are not well reasoned, right? That's the problem. And so therefore, I think what tends to happen is that that sort of reinforces this dichotomy between the courts and what they're doing in disputes vis-a-vis the constitution, right? Because if you have a badly reasoned judgment, then it's very easy to actually criticize it, right? And so, for example, again, to come back to our 370 case, which is just it's a great case study for so much of this, right? When the text of 370 says that the Constituent Assembly of Jammu and Kashmir, right, has to recommend any alteration to 370 before it's done, and the Supreme Court chooses to read that as optional, right? It's very easy to say, look, you've just invented some reasoning over there because you wanted to hold in this way, and so you have ignored the literal text of the Constitution there, right? And that's sort of, so it's very easy to say, okay, look, this is like a judgment that is not well reasoned. It ignores the clear constitutional text, and to stop at that point, right? But if we stop at that point, then, as I said originally, then we tend to miss out on really examining the Constitution itself more deeply, right? And that's where I think one part of the discussion is hampered, because we tend to then focus only on the bad judgment and not ask ourselves, okay, but was there actually could there have been a better argument for the court doing what it did? Had the court actually engaged more deeply with the text, could it have found better reasons to do this? And if yes, then what does that say about the way that we have designed this provision, right? The 370 in all its complexity. So I think the task of the book was to effectively, what in academia we call the principle of charity, which is to say that you give the other side the best possible arguments that could be there, even if they haven't made those arguments, and then ask yourself, okay, what does that say about this debate? So in this book, the idea is to actually provide the strongest possible argument that is there, and then to engage with that and say, okay, what does this tell us about the constitutional design, text, interpretation, and so on. On the point of secular and socialist, so I don't think either way it did too much, because and this is something the point people have made, that there are the secular nature of the Indian Constitution comes from not the preamble but Articles 14, 15, 25, 29, 30. And that is effectively the core of the secular foundations of the Constitution. And if the word is there or not doesn't make a difference. Socialism, debates about this are legion, but in my view at least, the Indian polity was never socialist. It was in the beginning a state-led market economy, and then it became a more privatized economy, but it was never socialist in the way you understand socialism as a way of organizing the political economy. And so again, for me, that addition or deletion really, beyond rhetoric, does not make a tangible difference.
During the emergency period, which were not the normal times, and many of the constitutional provisions were suspended during the emergency, liberty and...
But I don't think it made a difference tangibly to the constitutional design anyway.
No, so you're right. It was done during, and you asked your first part of your question was, what was the intent behind it? I guess the intent was that you have put in an emergency and you want to get support from the public. So from different sections. So you expressly carve out and say, oh, now in the preamble we are socialist, and now in the preamble we are secular. I guess you get a larger bunch of support to the measures you have done. So that was the intent. But like Gautam said, insofar as secularism is concerned, whether or not that amendment exists is not really material. Of course, in today's context, it becomes a very symbolic thing. In today's politics, it becomes very symbolic. But if you were to look at constitutionally, the provisions were always there, which showed that India was a secular state. Insofar as socialism is concerned, I think most of the provisions which you would associate with, depending on the definition you use of socialism, are in the directive principles. So they were really, in that sense, not enforceable anyways. And they have been, through some mechanism, through court interpretation, been made enforceable. But I think in 91, I think there was a sort of move away from, a very express move away from that. So either way, the point is that the amendments didn't really add or subtract much, and I do agree with that. It's today become a symbolic hot potato political issue, but if you look at it constitutional architecture-wise, it really doesn't make a huge difference.
Other comments? Left, center, right.
At the outset, huge congratulations for the book. It's just for providing us the new prism to look at the constitutions. So my question is regarding centralizing approach versus federalizing approach. You have mentioned in the book that it places a significantly greater interpretive burden upon the judiciary as far as federalizing approach is concerned. But for various reasons, taking the advantage of being here, I would like to know the reasons. Otherwise, I have my own reasons to assume, because in fact the things should have been the otherwise. Taking the advantage of diversity dividend that we have, the judiciary should have gone the other way, in which it didn't go. So I would like to know the 4 or 5 reasons which you can explain to us. Thank you.
Other questions on that side?
There's one.
Hi Gautam, I'm Vishwendra. So Ambedkar had a quote which I find interesting. Even good constitutions turn out to be bad if those running it are bad. So I bring this in the context of how the constitution trusts the state so much. In the context of how they put so many restrictions on the freedom of speech, public order, decency, morality. To me, I think Ambedkar trusted the state too much. And the feeling I get is, oh, we aren't going to abuse this constitution. It's only the bad guys who are going to do it. On the other hand, the Americans were very clear. Their First Amendment says, Congress shall make no law abridging the freedom of speech. They're very clear on this. So my rudimentary question is this: which approach do you think is more realistic?
Does anyone else want to talk about that? Sorry. Yeah.
I was talking in class. First to answer.
So can you just again quickly give the crux of your question?
In India, I think we trust the executive too much with how the restrictions on freedom of speech are very amorphous. On the other hand, the Americans are clear. The Congress shall make no law abridging the freedom of speech. So yeah, I mean, which approach do you think is more realistic in terms of trusting the executive with further power?
See, of course, there has to be a balance, and that's what is the ideal thing. But ideal things don't happen. Yes, there is I think that's what Gautam has also continuously said. Even the judiciary has continuously given it to the executive whenever there's a contestation between the civil society or the public representatives or the executive. So there is a strong push towards the executive. That's a fact. But there is now, if you see our society, we are in a state of flux. There's a lot of flux in our society. If you compare it with the US, it's not a fair comparison. So it was a very, very complex task for the founding fathers of this nation. They had to prioritize things. And I think in that time, there were some decisions which were taken. So the constitution was made in the way it was made. And of course, it was a living document. It had to move towards the other way, like the other friend said. Ideally, it should have moved the other way. But we are still seeing that it's not moving. My fundamental question is why? Which means the society is has not changed much, right? As long as we have hierarchies, as long as we have all these things everywhere in the society, how do you expect the judiciary and the parliament and the other people to move? So it's a very complex and it's a complex adaptive system. That's what I'm saying. It cannot be seen from in terms of an isolation. So right now, is it doing a good job is the question. Right now, I see it's doing its basic job. It has been doing its basic job. That is why some things are still surviving. Yes, we could achieve an ideal position, but we'll also have to see what we will lose by going towards specializations. Like typical example, I was in the civil service. There's always a question whether a collector is required or not. Whether you need a district collector, right? Now, if you compare with the US, you will have specialized officers for everything. Why not in India? Now, when I sit in a district like Raichur and see a villager coming to my office, he doesn't have to go to 100 offices. He just needs to come to the collector. And he hopes and believes that this guy will solve, which is phenomenally not possible. But still, there is a ease of something which is happening. And if at all the collector is expected to do his job well, he can get it done. So it's a mix of everything. It's a very complex question. But I believe fundamentally the Constitution has done a great job so far. But what has probably failed it is the way that it has been, maybe I think Gautam has not lost a chance to berate the judiciary and the entire. I think it's more of the critic of the judiciary than anything else. Yeah.
You want to say something?
No, I mean, just that, that eternal question between. So I think I'm totally with Dr. Ambedkar. He's not going to trust a village council that is not letting him drink water from the well. So you need a law for somebody to come and say that, guys, we can all drink from, the same bottle at some point. So I think that evolution to get to a point where you can trust the local council, local sense, etc., is a slight evolved thing. And for me, the Constitution's young is just 75. What's 75 in the life of nations and systems, and how many generations? If you just look at generations. So I think when you get to a certain point of treating people as equals, seeking fraternity, the other word from the preamble, and sort of, just an acceptance of that, then you can move to a local, which I think is the design, the way I see it. That is like the unwritten design. So if we, run a hot iron over the Constitution, those words will emerge, Gautam.
Yeah, so I think that, so first of all, I'm not a fan of the Americans, and So you say First Amendment, and I was, I spent a year in the US listening to like First Amendment, worship. I took a course on the First Amendment actually, because I was also at that time, enamored of it. And then you see they arrest this guy, for like waving a placard with something about Hamas, and you're like, where did the First Amendment go? So I think that. The Americans have a bit of a hypocrisy on this. They, when it comes to what they designate as, terrorism and all of that, then for them, First Amendment and all is gone. So I'm not sure if they're a good model. But I think the Ambedkar quote that you quoted, I think, is an interesting one. And actually, I have also quoted that at the end of this book to say that I think that I'm in partial agreement with the quote, but not completely. So, of course, individuals matter and individual decisions matter, and what individuals do in the space that they are given matters. But as Marx very famously said, you make history, but you make history in the conditions that are given to you. And in that sense, and one argument I make throughout the book is that the design of the Constitution makes certain paths easier and makes certain paths harder. Right, so and you're right in that it is an executive trusting document. That's very clear. But as Mr. Senthil said, there are reasons for that. And if you read Ambedkar's testimonies to the Southborough Commission and so on through the early 20th century, when you have a situation where he says that I can't get on the bus and nobody will do anything about it, nobody will say a word because that's the way you enforce a social boycott. The only body that can deal with the social boycott is something more powerful, which is the state, right? So you can see why he thinks that it's necessary to have that executive trusting document, because that's the only way you overcome the entrenched social, prejudice that's there, in there. Now, did that work over time? That's of course a debate that we can have. But yeah, I think that ultimately, it's not just about the individuals who run the Constitution, but the structures and design it creates constrains what those individuals can do, and also facilitates what they can do in certain contexts. Which brings me to, I think, the first question, which I think is also a very interesting one. Why the centralizing drift in the federal context of the court and the Constitution? So again, to come back to our example of Article 370, but a different part of it, Article 3, right? Article 3 of the Constitution authorizes the legislature to, through simple majority, effectively alter state boundaries, create new states, destroy a state, and so on. The reason why that provision was there in the Constitution and why it did not have the consent of the state before as a prerequisite is a very interesting reason, actually, because the boundaries inherited from the British, the provincial boundaries, had many different majorities and minorities already over there. So the concern was that if you grant the state assembly a veto over a decision to alter a state boundary or to create a new state, then within a particular state, there will always be a majority who will who will stop any attempt for other groups in the state to have their own states, and you can have many examples of that, Chhattisgarh, Jharkhand, and so on, right? So you have this. That's why it was there. Now in 370, you have the conversion of Jammu and Kashmir from a state to a union territory, right? And the intuitive argument somebody might make when they look at the constitution is, look, if Parliament can destroy a state through a simple majority, surely it can convert a state to a union territory. It seems something less of a power there, right? So if you have a greater power, surely you have the lesser power. And of course, now, we had many arguments, in fact, I think with strong arguments, that, effectively authorizing or giving this power would mean that technically this is a power to convert India from a union of states to a union of UTs, right? Which again is against the federal scheme. So clearly you can't have that power. But this is basically, you are trying to effectively fight against the text, right? The text is giving one impression of this sweeping central power. And then you are saying, look, but read it in context, there is an implied limitation there, and so on, based on constitutional principles, which is always a harder argument to make than just look at the text. It's so clear, right? And if you look at the text of the Constitution throughout, Article 3 onwards, all the way up to Article 356, you will see sprinklings of this skew in the text that gives more power to the center. And in the first major federal case that involved interpreting the Constitution on the question of this distribution of powers, which is West Bengal versus Union of India, which involved the question of whether there is an implied limitation in the Constitution that would prohibit the Union from acquiring state property. In fact, the court refers to all these sweeping powers in the Constitution and says, look, if the Union has been given all these powers, acquiring property is so minor, so surely it also has this minor power. So yeah, to answer the question, effectively, the constitutional text and design gives the impression of a constitution that skews towards the center in the federal arena, which then in turn reinforces interpretations that further favor the center in cases of dispute. That's the major reason that I see in judgments which go along the centralizing route in our history. Of course, it's not the only route. There is a federalizing route, which I've made an argument for that. But the constitutional text seems to indicate that it is easier to interpret the constitution in a centralizing way than in a federalizing way, is my reading of that. Do you have something?
No, so that's probably true that if you have text against you, especially like as a practicing lawyer, I would say that, there are 34 judges, everybody has their own judicial preferences. So if you have the text to begin with to help you, it's always helpful. But now we have this constitution, right? And we are not thinking of changing it en masse. So the point really is, we are not, and that's the concern from the left side, which I get, that, if you're going to attack the constitution or the way it is structured, it's going to be used by somebody else for alternative purposes. So the point really is that you have this constitution and it's here. And therefore, the only way you can work it in a more democratic fashion is through interpreting it, be it the judiciary, be it the executive, be it the legislature. There's not much else we can do it apart from pointing out that, yes, it is structured textually, maybe with a certain skew. And that's important to understand because it can be done. I think I gave 2 examples of recent cases where the court wants to do it, it can be done. It's not that difficult a task because especially constitutional adjudication is values-based adjudication in which text matters possibly the least in any form. Like in a contract, you would give maximum amount of weight to the text, right? Like that's more or less the beginning and the end unless it contradicts something. In a constitutional adjudication, you can have a text say, but you will even give that meaning to the text given the purpose you identify, etc. So I think it's a work which can be totally done by the court, by the executive, by the legislature, despite the skew which we find in the constitution.
Other comments? Something? Yeah.
Hi, so I'm Hardik, 5th year from National Law University, Delhi. So I saw there was a difference in how you'd approach the Constitution and the Constituent Assembly debates in the Transformative Constitution and this book, right? And I saw the germination of that during the Icon blog series that you did. And one question that comes to me is this mysticism and reverence that we give to the framers or the founders of the Constitution. How should we go about doing that in the future, right? Because in constitutional adjudication, I just look to Davinder Singh as an example. Dr. Ambedkar's words decades apart were taken widely out of context. For instance, his quotations on the award given during Ramsay MacDonald's era and in 1947, completely different context, but to forward the same idea. That reverence given at the start to Constitutional Assembly debates enables a lot of mischief in interpretation. So countering these questions alongside what was referenced before by Seema here, that there are attacks on the Constitution being colonial. How do we recompense the reverence that we give to the framers with the reality that we have now?
Hand up somewhere at the back there. Yeah. There'll be a video, yeah. Like in the next 2-3 days, or I have to ask them how long it will take. Yeah.
Is it all right? Can I ask the question? Yeah. Hi. I just wanted to understand, there have been judgments, like you've been continuously referring to Article 370, right? When it comes to the question of declaring it as a union territory, the only reason why the courts left it untouched was on the basis of a statement made by the Solicitor General. I mean, when we are talking about having a conversation with the power, how do you deal with something like that when the apex court itself is sort of not doing anything about it purely because a statement was made? Similarly, on similar lines, a statement was made in the equality marriage case also that, all right, we'll do something about it, we'll make a committee and we are going to look into it. Having questions that were referred to the Supreme Court, leaving them unanswered only on the basis of a statement, how far do you think it's justified for the Supreme Court on not acting on it?
What do you do? I mean, just like you rant on WhatsApp to your friends, I think, that's what you do. And then you let it all out and then you're okay after a while. Sometimes, at night you still feel angry about it, but, that's the way life is. That's about it. What's the other? Reverence to framers. This is really hard, right? Because the way that the assembly debates work is that, so Ambedkar as the drafting committee chairperson ultimately is tasked with responding to all the, points that come in the debates. And so in a certain sense, he has the last word on the way you understand a particular provision. But at the same time, the often, and if you look at the history, you'll see that what happened was that the real debate, or the first debate, took place in the internal Congress, party, meetings before they went to the assembly. That was where the dissent was aired out, and they had the debate, and then in the assembly they broadly voted on the party line, right? And so again, and the problem is we don't have the records of those debates. So in that sense, the assembly itself is one part of the story, but we don't really know. Often we don't know what the intention was because we don't have access to the space where the intention was framed or was formulated. So in that way, it becomes hard. So the reason why we rely on Ambedkar is, of course, because he has the authoritative voice in, the final voice in this is what the provision means. But there is a danger there, like you said, in then taking his voice for the voice of the assembly, which is not the case. It was, as Aditya Nigam said, it was a polyphonic assembly, right? Like it was many things were happening over there. So I think ultimately, there are ways to get around it. So there are ways where you for example, sometimes if there is a certain word that is there and then disappears after a debate, you can say, okay, look, the disappearance of that word means something. That what that word meant to do is clearly not now the intention of this provision, or not its meaning. If a word comes back in, right? When sedition, right? Sedition twice comes back in, is twice dropped. So you make the argument that, look, clearly this means that sedition was not meant to be a ground of restriction, in the assembly. So I think that there are ways to try and engage purposefully or meaningfully with the debates. I think the problem is that in court it's often used cynically, right? So it's like if you are looking to support one outcome, you will find that one line by Ambedkar And the most common misuse is the 10-year thing, right? So when he says that reservations are meant to end in 10 years, there is a piece by Anurag Bhaskar in the Indian Law Review scholarship that shows that he did not mean that all reservations are meant to expire in 10 years. It was specific to a particular political reservation. So you just cite that and you're like, okay, look, this must be so. And I think that is the risk of uncritically quoting the founders and saying, look, they said it and therefore we must read the constitution in this way now. Because it was a polyphonic assembly. So I think it's a minefield and one must be very careful. And I think finally, the right way for me at least is to understand that that one thing, the framers were human beings, right? They were obviously women and men who had experienced a lot and were bringing the experience to bear on constitution making. Many of them were remarkable individuals, of course, but they were human beings, A. And B, they were responding to what was happening around them. And I think that one thing we have to accept is that, so we think of constitutions as enduring for a long time, right? As documents meant to endure for a long time, meant to be for generation upon generation. But if we go deep, and this is not just about the Indian Constitution, any other constitution, inevitably what is happening at the time will impact the way you draft provisions of the Constitution. So I think to understand that the framers were operating in their context, and many of the design choices they made were influenced by that context and were not necessarily about looking into the far future, will also, I think, help to just treat the Constitution and the framers as human beings making a human document, and not beyond the scope of therefore,
Yeah, no, I'll just answer the second question from the lady at the back. So I think the 370 judgment really is, it's in all its part, it really is, a bad judgment, if I can call it that, just in pure logical legal reasoning. So main question was on 370, could you revert it? There, what the petitioners argued is, if the state was in a precedence rule, which is a state of emergency, can you sort of change that during that period? Can you make those equivalences from Constituent Assembly to a state legislature, then to a parliament, right? So, I mean, going by that logic, a court master could be a Chief Justice of India, like A is equal to B, B is equal to C, and therefore, the equivalences can just go on. Now, the Supreme Court, that's why I said the Supreme Court treats Kashmir and rest of the country slightly differently, and that's been the jurisprudence, is they don't want to decide that, and that's my reading of the judgment, I could be wrong. They don't want to decide what you can do in 356 in a state of precedence rule, and therefore you avoid that question of equivalence, which is the way, by the way, the government went, and you give a completely new articulation of, actually, guess what, post 1957, president could have any time unilaterally done it. So all this jamela, if I can use the Hindi term, of equivalences, why did the government bother? Post the Constituent Assembly of Jammu and Kashmir, the government could have President of India unilaterally. What's the point of 370 then? If it's a protection, federal protection, it is a provision without any substance, if that's the interpretation given by the Supreme Court. So that's the question one. They avoid that, so they're protecting the rest of federalism by really tanking the Kashmir question, really, right? That's what the Supreme Court has done there. That's point one. Then second, the second question they should have clearly, directly, which arose in the case, and everybody argued, both sides, is state versus UT, and can you downgrade it? And there were enough arguments both on text and on constitutional principles, and to duck that on the basis that a law officer has said something is obviously not something. A law officer can never bind a parliament. He or she cannot even bind an existing parliament, leave alone a future parliament. And Rajya Sabha anyways continuously changes, right? The composition every 2 years changes. So where is the question of a law officer binding, and that change will come only through the parliament again, because the exercise of Article 3 power. So that was again disingenuous. So really speaking, the core questions which were before the court either messed up in terms of the reasoning, which was on the face of it wrong, or refused to answer it. But that judgment really, as a precedent for constitutional law, is not doing a great job.
To the second question about how do you maintain the reverence for the framers, I think it's not mostly about this question of reverence, but it's basically about, the fundamental fight which is going on, in the sense what the framers of the constitution, what India, the idea of India was, and what it is now. Like, we cannot dissociate ourselves from this entire thing, in the sense we cannot stay from a third perspective and see how things are going to operate. We are inside that system, right? And then we choose to defend or we choose to take the other side. So this fight and our involvement in this is also a part. So it's not more about whether we continue revering them but are we going to take the side that they took is the fundamental question. And if we are going to do that, I think this fight will continue and we'll find ways of maintaining that in the courts, outside, in the streets, in the parliament. What I can say is that we are part of that fight.
Great answer. It's a good note to perhaps conclude on we can conclude, yeah.
Thanks.
Thank you. Welcome.
Thanks for all the 2 minutes, yeah.
Thanks.
Okay, thank you everyone for being such a great audience and for asking so many questions. If you have more questions, I think reading the book will help answer them. There are copies outside, so please do buy one.
Yes, it's a well thumbed book, yeah.
Transformative I read using Zlib, but I bought.
No, I have to. It's Westland, different publisher. Hope you have a copy of that.
Yes, I have already.
Oh, great.
Unless you are a subscriber and you have to click the agreement, the license agreement, that says that I accept that this might be open source. And you have to be 18 years.